Welcome to Making the Most of Immigration Sessions at the Conference, an online presentation. For the past few years, this information has been delivered in a fixed space and time at a session during the first session slot of the conference. This year, we'll be presenting virtually, so you can prepare for the conference in advance. We hope to accomplish two things. First, we want to give you a brief overview of the changes in immigration law, policy, procedure, and practice over the past year, and highlight the issues that might be most talked about at the conference. Second, we want to identify for you all of the immigration-related sessions at the conference so that you can plan your schedule. We'll divide our content into 4 parts. Part 1 will deal with SEVIS and SEVIS 2. Part 2 will focus on students and exchange visitors. Part 3 will deal with scholar and employment-based topics, and Part 4 will focus on cross-category topics like visas and port of entry issues, immigration reform, and the Affordable Care Act. After each part, we'll review all of the immigration-related sessions at the conference that relate to the particular topic. Also, please explore the downloadable resources connected to this presentation available on the Conference Immigration Content Portal at www.nafsa.org/AC12immigration, all one word. www.nafsa.org/AC12immigration. This includes printable lists of immigration sessions and workshops, slides and transcripts of this presentation, a detailed immigration update handout, and a glossary of acronyms, terms, and concepts. Let's begin with SEVIS 1. This past year there were 3 SEVIS releases, 6.8 in June 2011, 6.9 in October 2011, and 6.10 in April 2012. You can take a look at NAFSA's SEVIS Release Notice Update page to read all recent SEVIS system change notices. One of the biggest changes brought about by these releases is the addition of adjudicable fields. SEVIS Releases 6.8 and 6.9 made several key fields on Form I-17 adjudicable, which means that SEVP has to review and approve the update before it becomes active. Fields like average number of classes, teachers, instructors, students, and non-teaching employees, courses of study and time necessary to complete each are now adjudicable fields. Also, adding a DSO who is not a current PDSO or DSO is adjudicable, as is making a name change to a current DSO. Also, SEVIS will no longer allow the PDSO to add, update, edit, delete, or assign school officials after recertification application has been filed and is pending with SEVP. Schools face 2 main challenges when updating adjudicable fields on their Form I-17. First, adjudication times are unpredictable. While SEVP reviews the requested update, the school's Form I-17 is locked and no other updates can be made. And the school has to wait until SEVP approves the update in order for it to take effect and in order for it to be able to begin issuing I-20s based on the change. Second, SEVP has not issued clear written policy guidance on what they're expecting from schools when they update these fields. Schools have reported that they often receive 1 or more requests for evidence, RFEs, from SEVP, which ask for documentation and explanations to support the update request. The school has to respond to the RFE within a certain amount of time, and sometimes the documentation is difficult or time-consuming to obtain. NAFSA has asked SEVP to provide clear written guidance so that schools can prepare in advance to provide the necessary documentation and explanations. SEVIS 610 was implemented on April 20th, 2012. On the FM side in SEVIS RTI, H-1B cap-gap business rules were modified to prevent SEVIS from improperly shortening periods of OPT in cap-gap scenarios. Also, STEM OPT functionality was modified to check that the student's primary major is in a STEM-designated field. After this change, the Extend OPT link will no longer appear for students who do not have a STEM primary major. This modification was included in SEVIS 610 even though NAFSA argued to SEVP that STEM OPT should be available to a student based on both primary and secondary majors. SEVP is currently reviewing this. Finally, recertification functionality was modified to match SEVP's current policy of requiring all updates to Form I-17 to be made before submitting the I-17 for recertification. After this change, the PDSO will no longer have to click through all 5 pages of the Form I-17 to submit a recertification application. On the J side in SEVIS RTI, SEVIS will now allow the responsible officer or alternate responsible officer to add a J2 spouse or dependent record to an initial status J1 exchange visitor record even after a visa has been issued. Prior to SEVIS 610, after a visa was issued, you could not add a J2 record until the J1's record was validated. SEVIS 2. DHS and DOS continue to work on developing SEVIS 2, the next generation of SEVIS. Top on people's mind is often the question when. Over the last few years, we've heard several projected dates. As things currently stand, SEVIS 2 will most likely not become the system of record until at least 2014 or maybe even 2015. Here are some SEVIS 2 basics to help you navigate the dialogue and tutorials at the conference. First, remember that SEVIS 2 will be mostly paperless. Second, all individuals who have to interface with SEVIS 2, including students, DSOs, government officials, and anyone involved in the school certification or recertification process, will have to create an individual customer account. Third, a school's Form I-17 will be linked to each certificate of eligibility, so that the school can issue certificates of eligibility only for programs for which they're approved on their I-17. The I-17 will also be much more detailed and will include not only courses of study, but degree levels and the academic calendars associated with each program of study. Right now, you can continue to prepare for SEVIS 2 by paying attention to the SEVP website for updates regarding SEVIS 2, including opportunities to provide feedback to SEVP. You can also continue the dialogue on your campus regarding the business impact of SEVIS 2. For example, how will the paperless environment and individual customer account system be communicated to students and other stakeholders, and how will those changes impact business processes? SEVIS and SEVIS 2 sessions and events at the conference include the following list: SEVIS Hot Topics in SEVIS and visas for intensive English programs, and poster sessions involving regulatory issues and visa acquisition. There's also a session on using technology to enhance international student and scholar services efficiencies and SEVIS reporting. Also make sure to visit the Department of Homeland Security's 1 DHS Pavilion in the Expo Hall. That's booth 353 in the Expo Hall. There you can see SEVIS 2 tutorials and speak with SEVP and other DHS representatives directly. One side of the DHS Pavilion will have a classroom set up and be devoted entirely to presenting SEVIS 2 tutorials throughout the conference. The classroom will feature 6 stations where stakeholders can participate in a hands-on SEVIS 2 experience. Take a look at the topics that SEVP plans to cover regarding SEVIS 2. This part of the presentation will focus on major changes, trends, and issues impacting F1 and M1 students and J1 exchange visitors. Let's begin with recertification and I-17 update challenges. A school must apply to SEVP for recertification within 180 days of receiving a recertification notice from SEVP. The last day of the 180-day period is known as the Certification Expiration Date, or CED. SEVIS certification is automatically withdrawn unless a school submits and SEVP accepts a complete recertification package no later than the day before its CED, so it's a serious thing. One challenge faced by recertification applicants is that before submitting the recert application, the school's Form I-17 must be completely updated and accurate. For schools whose 180-day recertification filing window has already begun, the principal challenge is getting I-17 updates approved with enough time in advance to allow the school to submit its recert package before its CED is reached. Although SEVP has encouraged schools to regularly update their Form I-17 as a living document, SEVP has not provided clear written guidance on standards for I-17 fields. This sometimes results in a school not being aware that it needs to update its Form I-17 or how the form should be updated and documented, until its 180-day recertification window has already begun. I-17 updates can take quite a while, from a few weeks to a few months, and sometimes include numerous back-and-forth communications between SEVP and the school, as both parties try to come to a meeting of the minds as to how an I-17 field should be updated and what kind of supporting documentation has to be submitted. The 180-day clock does not stop ticking while I-17 updates are pending, and the adjudication process has brought some schools very close to their CED. This has created anxiety on both the part of schools and SEVP. Schools have found the following I-17 updates particularly challenging. Updates to fields of study and courses of study and time necessary to complete each. SEVP often asks for documentation of the programs and evidence that the field or course of study has been approved by the school's accrediting body. Instructional sites. SEVP has been instructing schools to use the Add New Campus function in SEVIS to add all physical locations where an F1 or M1 student may take a class, referring to these as instructional sites, even if the school does not consider that location to be a campus. NAFSA has a practice resource on this topic. Operating authority and licensure. SEVP has been asking for letters from the state authority confirming the school's operating authority. This has been challenging for schools that are directly authorized by state law. Accreditation. SEVP sometimes asks the school to provide documentation from the school's accrediting body to establish that a course of study or instructional site has been accredited by the accrediting body, despite the institutional nature of school accreditation. Finally, adding DSOs. SEVP now requires schools to document a new DSO's status as a regular employee by submitting a copy of the Form I-9 the school completed as the employer. Also, SEVIS will no longer allow the PDSO to add, update, delete, edit, assign school officials after a recertification application has been filed and is pending with SEVP. You can take a look at SEVP's August 2011 broadcast message, which provided information on SEVIS password policy and outlined the requirements and documents for processing PDSO and DSO updates. Several student-related initiatives that you should be aware of include the DHS Office of Academic Engagement and Study in the States. Visit the studyinthestates.dhs.gov website for more information. Some schools may have received visits from ICE officers as part of ICE's Campus Sentinel program. Campus Sentinel is an outreach initiative established in April 2011 by ICE's Homeland Security Investigations, or HSI, division. The purpose of this outreach program is to build partnerships between HSI's Special Agent in Charge, or SAC, offices and SEVP certified institutions. Regional liaisons. SEVP has begun staffing its new Field Representative Unit, which will have 3 regions, East, Central, and West. Each region will have a regional manager and 20 field representatives. Hiring of field representatives is expected to begin this year. For more details, make sure to attend the new SEVP field representatives and how they will affect your work session at the conference on Thursday, May 31st at 2 o'clock. Finally, the Student and Exchange Visitor Program, SEVP, has been realigned to a higher level within the Department of Homeland Security, to an Assistant Directorate level. SEVP has also consolidated numerous operational activities under 2 operations units: an internal operations unit that manages SEVIS technical work and other management functions, and an external operations unit that manages SEVP policy, school certification, the SEVP Analysis and Operations Center, and the new Field Representatives Unit. Student-related policies you should be aware of include regulatory packages. SEVP has been planning a non-substantive rewrite and reordering of the text of its regulations in conjunction with USCIS. SEVP is also working on a proposed rule to implement key elements needed for SEVIS 2. In January 2012, DHS also announced a series of administrative reforms geared towards attracting the best and the brightest. Student-related reforms announced include expanding eligibility for STEM OPT extensions, allowing for additional part-time study for spouses of F1 students, and expanding the number of DSOs a school can appoint. None of these have yet been published as proposed rules, however. Special student relief. Over the past year, DHS published notices granting special student relief benefits to F1 students from Haiti, Libya, and Syria. A May 11, 2012 update to the DHS STEM designated degree program list added several new fields as well as numerous 99 fields, zip codes ending in 99. Those zip codes ending in 99 had been excluded from the list prior to the 2012 update. This list is used to determine eligibility for STEM OPT extensions. Review the list in detail. IEP Accreditation Compliance. On April 21, 2012, SEVP posted a notice explaining its plans for ensuring compliance with Public Law 111-306, which is the Accreditation of English Language Training Programs Act. This act requires intensive English language programs, or IEPs, to be accredited by a regional or national accrediting agency recognized by the Department of Education. The law became effective on June 12, 2011, but there were provisions that gave non-accredited intensive English training programs that were already SEVIS certified 1 year from the date of enactment to apply for accreditation. To allow time for the accreditation process to be completed, the law also allows F1 students to enroll in such non-accredited programs for 3 years after enactment, provided the program had applied for accreditation by December 15, 2011. SEVP has evidently grouped IEPs into two categories: standalone English language training programs and combined English language training programs. Although SEVP does not fully define these two groupings, it's assumed that standalone refers to SEVIS certified schools that offer intensive English language instruction in their own facilities and as their primary or only course of study. The notice states that combined programs are intensive English language programs of study affiliated with another SEVP certified institution either through a contract or incorporated into the institution's offered curriculum. The latter group would include most colleges and universities with ESL programs. SEVP stated that it will initiate an out-of-cycle review of combined programs to verify compliance. The review will be used to collect documentation regarding the school's accreditation status and language program governance structure. NAFSA sent a memo to SEVP urging them to reassess their approach to applying the accreditation law and to communicate its policies regarding the applicability of the IEP accreditation law to the public, either through the regulatory process or through formal written policy guidance, with an opportunity for public input. NAFSA also urged SEVP to properly take into account the law's legislative history, which describes two ways a language program can comply with the law: either be under the governance of a university or college that has been accredited by a regional accrediting agency, or they can be individually accredited. In developing its policies in this regard, NAFSA urged SEVP to incorporate basic principles of institutional accreditation, such as the non-discipline specific nature of institutional accreditation and the purpose of the Department of Education's substantive change rules for accrediting bodies. Finally, NAFSA asked SEVP to work with accrediting bodies directly to develop protocols and set expectations so that SEVP's needs can be met without needlessly disrupting the work of schools or the accrediting bodies. For student issues at the conference, make sure to attend the following sessions. Also remember to visit the DHS Pavilion, booth 353 in the Expo Hall to see SEVIS 2 tutorials and speak with SEVP representatives directly. In the world of J1 exchange visitors, first, Robin Lerner was named Deputy Assistant Secretary of State for Private Sector Exchange in the U.S. Department of State's Bureau of Educational and Cultural Affairs, a position that was previously held by Stanley Colvin. DAS Lerner's duties include overseeing the J1 Exchange Visitor Program, which consists of two offices: the Office of Exchange Visitor Program Designation and the Office of Exchange Coordination and Compliance. Regarding regulations and policy affecting J1 exchange programs, the Office of Management and Budget, or OMB, is reviewing or has reviewed 4 rules submitted by the Department of State dealing with the teacher, summer work travel, au pair, and secondary school student categories. At the time this presentation was prepared, there had been no further updates regarding the status of revisions to exchange visitor regulations in Subpart A. EVP site visits and compliance activity. Let's begin with noting that the exchange visitor program over the course of 2011 and 2012 visited approximately 21 of the largest academic and government exchange programs. In its notices, DOS EVP stated that the visits are part of our efforts to collaborate closely with exchange visitor program sponsors and to allow for public participation in the regulatory and oversight process. According to the DOS EVP notice, the visits lasted approximately 2 days, and programs were asked to make staff available for interviews and to respond to requests for documentation. Sponsors were also invited to share best practices with DOS EVP, as well as issues the sponsor wished to bring to the attention of EVP. You can see a sample of the DOS EVP inspection notice and checklist on the NAFSA website. A number of exchange visitor programs also reported that they have received requests from DOS to provide details about their arrangements with Confucius Institutes, which are funded by the People's Republic of China to expand the teaching of Chinese language and understanding of Chinese culture throughout the world. DOS requests commonly ask for copies of Confucius Institute Scholar Invitation Letters, DS 2019s, sites of activity, a description of the activities conducted by the scholar, including details of their teaching assignments, and copies of any agreement between the U.S. college or university and the Confucius Institute. DOS notices to programs indicate that they are requesting this information to better understand the program activity associated with Confucius Institutes. SEVIS 610, implemented on April 20th, 2012, added functionality to allow adding a J2 dependent record to J1 records even after the J1 has received a J1 visa. Prior to this change, if a J1 received a J1 visa, you could not add a J2 record until the J1 record was validated. Make sure to attend the Exchange Visitor Program Update Hot Topics in J1 Processing on Thursday, May 31st at 8 a.m. There may also be some SEVIS student and employment-based sessions where exchange visitor issues could be discussed. Moving on now to employment-based topics, let's begin with prevailing wages. There was new functionality added to iCert that allows customers to upload wage surveys, for example, employer-provided surveys or other supporting documentation, to the NPWC as part of the ETA Form 9141 prevailing wage request submission process. The documents have to be submitted in either Microsoft Word, Adobe PDF, or text file formats. The change also now allows electronic requests for NPWC Center Director review. This can now be initiated through iCert and does not have to be processed through the mail. DOL also issued a new set of frequently asked questions, including one on how employers should enter untitled custom wage survey information on ETA Form 9035, including a table of DOL-recognized captions for commonly used surveys. The facts also include information on how to change iCert access information. Employers who file permanent alien labor certification applications through PERM should be aware of several favorable decisions by the Board of Alien Labor Certification Appeals, or BALCA. BALCA found that unlike the standard PERM filing advertising provisions that specify a print ad requirement, the special handling rules do not prohibit advertising in an online or electronic national professional journal. The Office of Foreign Labor Certification, OFLC, updated its FAQs to be in accord with this BALCA decision. The practical question faced by employers now is what constitutes an electronic national professional journal? NAFSA has a resource entitled Electronic and Print Advertisements for College and University Teachers to help with answering this question. Other BALCA decisions include one on teaching duty requirements in special handling PERM applications, one on teaching hospitals' affiliation for ACQUIA eligibility, one on when recruitment begins for purposes of prevailing wage determination validity in standard PERM filings, one on permanence in PERM cases, and one defining what constitutes a newspaper versus a national journal. Regarding the H-1B cap, fiscal year 2012 H-1B cap was reached on November 23, 2011, and the fiscal year 2013 H-1B filing season opened on April 2, 2012. USCIS keeps track of H-1B cap number usage on its website. Although employment at an institution of higher education is exempt from the cap count, students often apply for employment with cap subject employers, so it is useful to know how to keep track of H-1B number usage. SEVIS 610 contained improvements to cap gap extension functionality that will hopefully eliminate some problems reported in the past, such as SEVIS automatically shortening OPT or terminating a record when it shouldn't. The improvements do not address the reliability of the claims SEVIS data interface, however, so they will only work if claims properly updates the SEVIS record with H-1B filing data. In January 2012, DHS announced a series of administrative reforms geared towards the administration's commitment to attracting and retaining the best and the brightest. Scholar-based reforms will include allowing outstanding professors and researchers to present a broader scope of evidence of academic achievement, and harmonizing rules to allow E3 visa holders from Australia and H-1B1 visa holders from Singapore and Chile to continue working with their current employer for up to 240 days while their petitions for extension of status are pending. These changes will require rules to be published, and as of yet, DHS has not published proposed rules. At the conference, make sure to attend the following sessions related to employment-based topics and scholar topics. Moving on to cross-category topics, let's begin with USCIS processing. First, let's talk about USCIS's ELIS electronic immigration system. USCIS is still planning to launch its transformation electronic filing and case adjudication system known as ELIS, which stands for Electronic Immigration System. The first ELIS form scheduled to be made available is Form I-539. During the first phase, users will be able to create accounts and to use the ELIS I-539 on a voluntary basis, as paper filing will continue to be available, to request the following benefits: extension of status as a B1, B2, M1, or M2, a change of status to B1, B2, F1, F2, J1, J2, M1, or M2, and a reinstatement of status to F1, F2, M1, or M2. The ELIS I-539 was originally planned to become available in December 2011, but implementation was delayed. At the time this presentation was prepared in early May 2012, USCIS was saying to expect ELIS soon. For more recent updates on ELIS, see the USCIS ELIS page and attend the U.S. Citizenship and Immigration Services Hot Topics session on Wednesday, May 30th at 10:15. Regarding Service Center operations, USCIS has instituted an expedited case review process to resolve adverse decisions resulting from certain USCIS administrative errors. The process could be used, for example, if CIS denied a benefit request based solely on the applicant's failure to respond to an RFE, but the customer has documentary evidence that she or he actually did respond to the RFE and that USCIS received the response in a timely fashion. Some changes on I-797s. USCIS resumed sending the original I-797 receipt and approval notice to the attorney or accredited representative listed on Form G28. It's also changed the appearance of its Form I-797C, which is used to communicate non-immigration benefit information, for example, receipt of payments, rejection of applications, transfer of files, and other similar notices. USCIS stopped issuing Form I-797C on special paper and began using plain bond paper. CIS estimates that this change will save taxpayers about $1.1 million per year. Updates regarding visas include a interview waiver pilot program. On January 19, 2012, the Departments of State and Homeland Security began a 2-year visa interview waiver pilot program. This program allows consular officers to waive interviews for qualified applicants who are renewing their visas within 48 months of the expiration of the previous visa and within the same classification as the previous visa. If the consulate's program covers F, M, or J applicants, they must also be renewing their visa to continue participation in the same program or attendance at the same institution as with the previous visa. So far, NAFSA is aware of interview waiver pilots being run in India, China, Brazil, and Norway. Others may be added. Each pilot program is different, however, and each program covers different non-immigrant categories. Not all of the pilots cover, for example, F, M, or J applicants. So applicants should check the consulate's website for specific details and procedures. New visa fees were effective April 13, 2012. You can check the Federal Register notice, which is posted on the NAFSA website, for details. All of the immigration-related agencies have been quite active in monitoring regulatory compliance. ICE has increased I-9 audits and inspections. There's the Campus Sentinel program that was discussed earlier in the student portion of this presentation. SEVP is conducting out-of-cycle reviews. USCIS has fraud audits and visits. DOL has compliance audits, and its Wage and Hour Division investigates pay issues. DOS investigates visa fraud, and the Exchange Visitor Program has been conducting reviews and site visits. The important things to remember are to get back to the basics. Review your regulatory obligations and be sure that your policies conform to the actual wording of the regulations. You should also understand penalties and liabilities, and each institution should consider establishing a response team to manage site visits and audits. To hear more about this topic at the conference, attend the following sessions. The agencies are also interested in engaging with stakeholders. Keep up with NAFSA liaison with the government on the NAFSA website. We also post a quarterly agency engagement newsletter that summarizes NAFSA engagement with the agencies. NAFSA Executive Director and CEO Marlene Johnson was appointed to serve on the Department of Homeland Security's Homeland Security Academic Advisory Council, HSAC, which was formed by DHS Secretary Napolitano to develop recommendations for attracting the best and the brightest international talent, while at the same time strengthening the mission of the Department of Homeland Security. Ms. Johnson was appointed along with 19 other academic leaders and presidents of U.S. institutions of higher education, and she will serve on the Subcommittee on International Students. The Affordable Health Care Act, the Patient Protection and Affordable Health Care Act, will be phased in over the next few years. Under the Act, most individuals will be subject to a requirement that they obtain minimum essential health insurance coverage or face a fine. This is sometimes called the individual mandate. At the time this presentation was prepared, certain aspects of the Act were being reviewed by the U.S. Supreme Court. This and other factors may impact implementation of the Act. Some common questions to consider are, to what extent will non-immigrants be subject to the individual mandate in 2014? For example, what's the effect on short-term visitors, students, and scholars? Would a failure to obtain essential minimum coverage affect non-immigrant status and eligibility for immigration benefits? And how would a violation of non-immigrant status impact an individual's responsibilities and eligibility for the benefits under the Act? Second, will a school's student health plan meet regulatory requirements? And how will the Act otherwise impact how schools offer or require their student health plan? For employers who must ensure that minimal essential coverage is available to employees, what constitutes an employee? Some resources to help navigate these questions include reading the text of the Patient Protection and Affordable Care Act itself, a CRS report, a Congressional Research Service report entitled Treatment of Non-Citizens under the Patient Protection and Affordable Care Act. There's also an HHS final rule that defines student health insurance coverage as a type of individual health insurance coverage under the Affordable Care Act. The government's www.healthcare.gov website also provides important background information. Regarding Real IDs, states must be in full compliance with the provisions of the Real ID Act by January 15, 2013. On immigration reform, explore NAFSA's position on immigration reform. On its website, NAFSA has a policy statement on the need for a national conversation on immigration reform, and you can also stay tuned to NAFSA's webpage, A Way Forward on Immigration Reform. To hear about immigration reform issues at the conference, come to the session on Wednesday, May 30th at 11:45, U.S. Government Policymaking Issues and Trends Affecting International Education, and on Friday, June 1st at 10:30, Framing the U.S. Comprehensive Immigration Reform Conversation, a training for international educators. Cross-category topics at the conference include the following: This is the end of the presentation. We'll leave some time for you to review these sessions. Remember to visit the Annual Conference Immigration Update portal at www.nafsa.org/AC12 Immigration, all one word. There you can find printable lists of immigration sessions and workshops. Download them and prepare for your conference in advance. See you in Houston.